Sir, if we are ready, then shall I begin with the introduction? Hello, sir. If we are ready, then shall I begin with the introduction?
Yes, sir.
O- Okay, sir. Good evening, everyone. I, on behalf of Legal Expatiate, would like to welcome you all to the third session of this 5-day online course on procedure of courts and tribunals. For today's session, we are honored to have with us Advocate Siddharth Chapalgaonkar, an accomplished legal professional whose journey reflects both versatility and excellence. Starting his career as a civil engineer, he transitioned into law with a vision to contribute to the techno-legal domain, eventually developing a strong practice in general litigation. After completing his LLB from ILS Law College and enrolling with the Bar Council of Maharashtra and Goa in 2019, he practiced before the Bombay High Court under the guidance of Mr. Nitin P. Deshpande, handling diverse matters in civil, criminal, commercial law, and arbitration. He later moved to Delhi and worked under the mentorship of Mr. Dama Sheshadri Naidu, former judge of the Bombay High Court and senior advocate at the Supreme Court of India. Since 2023, he has been in independent practice and regularly appears before the Honorable Supreme Court of India, Delhi High Court, NCLT, NCLAT, and various district courts. Currently practicing as an advocate on record before the Honorable Supreme Court of India, he brings with him valuable insights from a unique journey spanning engineering, litigation, and independent advocacy. We all are really honored to have you for today's session, sir. Without further ado, I now request sir to take the charge of session. Over to you, sir.
Thank you so much. First of all, I thank Legal Expatiate for giving me this opportunity to give this lecture on Supreme Court practice and procedures. I have shared one document with Akanksha. It's a 10-page note I have prepared. So that will be, you may just see it after the lecture or you may just go through it when I am delivering this lecture. I am going to primarily refer to that. And if if you want me, I can share that screen also with you, or maybe the moderator will share it. I have shared it with Akanksha.
Sir, if it is okay, it will better if you can share it from your side, sir.
Okay, I'll just try. Let us see. It's open on my.
Yes, sir.
Can you see this now?
Yes, sir, it's visible.
The note you can see, right?
Yes, sir.
Yes. So this is the note I have prepared. So first of all, I'll on the first page you can see that what all I am trying to touch this in this lecture. So first is the what are the basic resources when we talk about Supreme Court and its practice. What are the basic resources that we require? First is obviously Constitution of India, Supreme Court being constitutional court. It derives its powers from Constitution of India. So Articles 124 to Article 147 deal with the Supreme Court. Second is the Supreme Court Rules 2013. Now, as you are aware that you might have seen in last two lectures or in your practice or in internships, you might have seen that there are civil manuals, criminal manuals, or every court is governed by their own rules. For example, in High Court, if you practice in Bombay High Court, there are Bombay High Court Appellate side rules and Bombay High Court original side rules. In same manner, Supreme Court is governed by Supreme Court Rules 2013. Now, previously there were Supreme Court rules of 1966, but from 2013 these new rules were formulated and each procedure in Supreme Court is governed by these rules. Then the next resource is Handbook of Practice and Procedure. Now this handbook was designed and published in 2017. So this is more detailed explanation about the rules of every procedure. I have actually shared the link. So if you get this note, when you click on this note, you will immediately be directed to the handbook of practice and procedure. And last is will require. Then I am going to discuss three more points, important points. The first is the jurisdictions of the Honorable Supreme Court of India. Now, this discussion is very much important because Supreme Court, as we everyone knows, that this is the final court. There is no court above Supreme Court. So, what are the jurisdictions? And for this, I have in this note incorporated in detailed manner because when we talk about jurisdictions of the Supreme Court, we get guidance from two documents which I have already uh, talked about. One is the Constitution of India, and second is the Supreme Court rules. So, in my note, whatever I have prepared, it was during my AOR examination, the faculty had prepared this note. So, I've actually incorporated that note. The third point I would like to deal is filing to listing. So, I would like to just give an idea that how the matter is filed, then how does it get listed? It again, every court has different procedures. Supreme Court also has its own procedures. And last is the appointment of judges in the Supreme Court of India. Now, this topic may not be related to the practice and procedure, but this is very important because it is always in news. Now, every one of us know that even yesterday there was an ordinance where the strength of Supreme Court has been increased from 33 to 37 judges with Chief Justice of India. So the strength is going to be 38 judges. So how the appointments are made. So it's always a topic in discussion. Therefore, I'll try to touch these topics in my lecture. So first is jurisdiction of the Supreme Court. So now there are how many jurisdictions? So there are around 4 to 5 jurisdictions. The first is appellate jurisdiction. Now there are, when a high court passes an order or any other tribunal. So if you have, you should know that there are many tribunals that function. For example, NCLAT. From NCLAT, the direct appeal lies to the Supreme Court. From National Green Tribunal, there is a direct appeal. So there are various other tribunals from which a direct appeal lies to the Supreme Court. Therefore, these appeals, so one from High Court and from other tribunals, those appeals are governed under the appellate jurisdiction. So, which is the first appeal? So, that is appeals permitted under Article 132. Now, how this appeal under Article 132 is filed? High Court certifies under Article 134A that the case involves substantial question of law as to the interpretation of Constitution. That is one type of appeal. Then under Article 133, High Court certifies under Article 134A that the case involves a substantial question of law of general importance. And third is Article 134 of the Constitution, read with Orders 19 and 20. Now, these Orders 19 and 20 are of Supreme Court Rules 2013, which you can see. You can just download Supreme Court Rules or get the book, and you will understand what are Orders 19 and 20. Now, if you see this Article 132 and 133, there is slight difference. The first is case involves substantial question of law as to the interpretation of Constitution. And in Article 133, it is the case that involves a substantial question of law of general importance. Now, there can be a difference. Why there is a difference between these two? If you remember, there was one judgment by Delhi High Court where there was a differing opinion with relating to marital rape. So one judge ruled in the favor of petitioners and other judge deferred, and that question was referred to Supreme Court. So this will amount to substantial question of law of general importance. Likewise, maybe I can give you an exercise. Even I don't know when a High Court has referred under Article 132, where it involves the question of law as to the interpretation of Constitution. We can find this maybe after our lecture. Then, as I said, there are appeals arising out of statutes. Now, these statutes are various different statutes. So, first is appeal under Section 35L of the Central Excise and Salt Act. Second is appeal under Section 23 of Consumer Protection Act. And now, under new act, it is Section 67 of Consumer Protection Act. Then there is appeal under Section 19(1)(b) of the Contempt of Courts Act. Now, this is very interesting. I'll just tell you, where in Contempt of Courts Act, if a High Court punishes someone with contempt, then he can appeal under Section 19(1)(b) of Contempt of Courts Act. But if a contempt petition is dismissed, then the aggrieved person doesn't have remedy of appeal. He will under Section 116A of the Representation of the People Act. Now, in election petitions, the first, when the election is of a member of parliament or member of legislative assembly, the court of first instance is High Court. So after the High Court passes the judgment, there is a statutory appeal, that is Section 116A of the Representation of the People Act. Next is the appeal under Section 18 of the Telecom Regulatory Authority of India Act. Then there is appeal under Section 15Z of Securities and Exchange Board of India Act. Next is appeal under Section 261 of the Income Tax Act. 53T of Competition Act. Appeal under Section 125 of the Electricity Act. 29(1) of the Wealth Tax Act. So there are various appeals. Now, Section 22 of the National Green Tribunal Act, Section 10 of the Special Court, Trial of Offence Relating to Transaction in Securities Act 1992, appeal under Section 62 of the Insolvency and Bankruptcy Code, appeal under Section 19(1)(b), so that is again repeated, and appeal under Section 374 of the Code of Criminal Procedure. So these are the various appeals that lie before the Supreme Court, direct appeals. Third category under appeals is appeals under Section 2 of the Supreme Court Act 1970, read with Order 20 of the rules. Now, this is also a very interesting appeal. If in a criminal court, when in a trial, Sessions Court acquits the accused, and in an appeal, High Court convicts the accused, then that reversal can be challenged directly under appeal under Section 2 of the Supreme Court Act 1970. If it is otherwise, like if there is a conviction by Sessions Court and High Court has acquitted, against that acquittal, there is no appeal, because this Section 2 of Supreme Court Enlargement of Criminal Appellate Jurisdiction is only for the reversal in cases from acquittal to conviction. So this you may keep it in mind, that it may happen that if you are practicing, let's say in High Court, and if there is a reversal, then you know that while you file a matter in Supreme Court or refer it to some AOR in Supreme Court, that this appeal will lie when there is a reversal from acquittal to conviction. Then last is the appeals upon grant of special leave to appeal under Article 136 of the Constitution. Now, this appeal is the widely practiced. Like if we see the Supreme Court practice, 90% of the practice is Article 136. So this is extra. From this, we come to the second jurisdiction, that is extraordinary appellate jurisdiction. So this is petitions for special leave to appeal under Article 136 of the Constitution. So these are governed by Order 21 and Order 22 of the Supreme Court rules. So this is widely practiced jurisdiction. Any order. So if I'll just read 136 for you, it is not quoted here. In 2 minutes, I'll just read what it says. You may just take out your constitution books if you have, or you can just Google it. Special leave to appeal by the Supreme Court. What it says first is, notwithstanding anything in this chapter, the Supreme Court may, in its discretion, grant special leave to appeal from any judgment, decree, determination, sentence, or order in any cause or matter passed or made by any court or tribunal in the territory of India. Second, nothing in this clause 1 shall apply to any judgment, determination, sentence, or order passed or made by any court or tribunal constituted by or under any law relating to the armed forces. So, second is, if there is any law that is relating to armed forces or any judgment that is passed by armed forces tribunal, that will not be subject to Article 136. But first is very important, that any order, any judgment, any decree, any determination, sentence, or order in any cause or matter passed or made by any court or tribunal in the territory of India. So essentially, if a district court passes an order, and if you are able to show that it is ex facie illegal, and it can be, if we are able to show, it is not necessary that you should go to High Court, but if we are able to show that a special leave to appeal can be granted in this by the Supreme Court, then directly a special leave to appeal petition will lie under Article 136 of the Constitution of India, because it says that decree or order or judgment from any court. Obviously, we are not going to do that, but there are some examples where I'll just tell you one example which I have not dealt with, but my senior had this matter. So there was one matter arising out of family courts pending before the Supreme Court. Which are not high courts. Some orders from directly from tribunals can be challenged. For example, NCLAT. Now we have seen that from NCLAT directly an appeal lies to the Supreme Court. But what about the orders that are interim in nature? So that are not appealable. So therefore, a special leave petition can lie under Article 136 of the Constitution of India. So likewise, in any case, a special leave petition can lie. It is similar to somewhat remedies that we have under Article 227 when we before the High Courts. Though there are appeals provided, many a times Article 227 or 226 petitions are entertained by the High Courts. Third is the original jurisdiction. Now, as we know, the under Article 226, we can file a writ petition before the High Court. So in High Court, the powers of writ jurisdiction are wide, that the High Court can issue writs for violation of fundamental rights as well as other legal rights. But in Supreme Court, the powers are limited. Article 32 writs can be issued only in case of violation of fundamental rights. So if we prefer a petition under Article 32, we should be able to show that there is violation of fundamental rights. And for this purposes, same writs that you must have studied in your High Court lecture, or you know that. What are those writs? First is nature of habeas corpus. Second is mandamus. Third is prohibition. Fourth is quo warranto. And fifth is certiorari. So these are the writs that are issued for the enforcement of fundamental rights. I'm not explaining these writs because you already know it and you can anyway read about them. Next is the original suits. Now in Supreme Court, the original jurisdiction under Article 131 is for original suits. Now, what are these original suits? A dispute between two states or dispute between two or more states. So these two disputes can be resolved under Article 131 of the Constitution of India by filing original suits. A good example I can tell you is that for a Belgaum dispute, we know from Maharashtra and Karnataka, that dispute is actually pending in Supreme Court since last 22 years now. So this original suit has been filed by state of Maharashtra against the state of Karnataka. Again, whether Supreme Court can actually resolve this dispute, or does Supreme Court have this jurisdiction? It does have jurisdiction under Article 131, but when it comes to land boundaries, whether Supreme Court has this jurisdiction or not, you may research it. Even I will research it, because this is the question, and I think the objection has been raised by the state of Karnataka on that aspect also. But this is the point, that any dispute between two states can be resolved under suits under Article 131. But there is one exception. Under Article 262, Parliament by law may provide for adjudication of dispute with respect of interstate river. In such case, the Supreme Court shall not exercise jurisdiction. So, when it comes to disputes of waters, that is rivers specifically, then Article 262 provides that Supreme Court will not have any jurisdiction, but Parliament may by law formulate a tribunal. Then again, you are aware about this, that various rivers, especially in South India, there is Krishna Water Disputes Tribunal, there is Kaveri Water Disputes Tribunal, even there is Godavari Water Disputes Tribunal, in which Maharashtra is part of that dispute against Andhra Pradesh and one more state. So this you may keep it in mind. Then there are petitions under Article 139A of the Constitution, read with Order 40 of the rules, seeking transfer of cases involving the same or similar substantial questions of law pending before the Supreme Court and one or more high courts, or before two or more high courts. Now what happens is, this Article 139A1 is the power of Supreme Court to transfer cases. But which cases? That where there is similar question of law pending before different high courts. There was this matter recently, of gaming, I think so, regarding lottery and gaming. Various petitions were filed in high courts, and all those petitions were clubbed by there is a judgment of Justice Chandrachud and Justice Pardiwala, which there are different grounds of transfer, maybe convenience, or maybe change of any, for example, office of the respondents and petitioners. So therefore, a case can be transferred from A place to B place. Third is petitions under Section 25 of the Code of Civil Procedure, seeking transfer of any suit, appeal, or other proceeding from a high court or civil court in one state to a high court or other civil court in any other state. So this is, if you must have heard as a practitioner or as an intern, the powers under Section 25 of this CPC are exercised in transfer of matrimonial proceedings. There are many matrimonial cases which are getting filed nowadays for transfer of, for example, divorce petition filed in a state, a district in Madhya Pradesh to a state in a district in Maharashtra. So these type of transfer petitions are filed under Section 25 of the Code of Civil Procedure and Order 41 of the Supreme Court Rules 2013. Next is the petitions under Section 406 of the Code of Criminal Procedure, also Section 446 of BNSS. So this is for transfer of any criminal proceedings from one court in one state to other court in other state. So this is for transfer of criminal procedures, criminal trials. Again, this power is also exercised very sparingly, especially petition under 406, because Supreme Court does not easily transfer criminal cases. There are some grounds that there should be allegation of bias, or there should be real apprehension of bias only, or threat to the life of any party or witnesses. Only in those cases the Supreme Court exercises transfers in criminal cases. Next is petition under Part 3 of the Presidential and Vice Presidential Elections Act 1952, read with Article 71 of the Constitution. So president and vice presidential elections are always challenged in Supreme Court under the Act, Presidential and Vice Presidential Elections Act 1952, and no other court has any jurisdiction. Next is petition under Section 11(5) of the Arbitration and Conciliation Act, read with appointment of arbitrators by the Chief Justice of India scheme 1996. Now, this power, generally Section 11(5) of the Arbitration Act, for appointment of arbitrator, is used in international arbitrations. So all the petitions for international arbitrations, for example, an entity between an Indian entity, a dispute between Indian entity and any foreign entity has to be resolved through arbitration, then the appointment will be made under Section 11(5) of the Arbitration and Conciliation Act by the Supreme Court under its original jurisdiction. Then the next is extraordinary original jurisdiction. Again, this is Article 32, but as I said that when we discussed Article 32 in the third part, that is original jurisdiction, it was relating to issuing writs under Article 32 for violation of fundamental rights or enforcement of fundamental rights. But in this case, this for extraordinary original jurisdiction, this Article 32 is for cases under public interest litigation. Therefore, petitions under Article 32 of the Constitution of India, read with Part 3B, Order 38 of the rules, in the nature of public interest litigation, seeking redressal of public injury, enforcement of a public duty, or vindicating interest of public nature. Petitions under Article 32 of the Constitution, seeking transfer of cases involving the state of Jammu and Kashmir in furtherance of right of citizen to access justice under Article 21. The next jurisdiction is advisory jurisdiction. So first is reference by President under Article 143(1) of the Constitution, read with Order 42 of the rules on a question of law or fact of public importance. Now you are aware that recently there was a presidential reference that was regarding the timelines that can be stipulated for assent of bills to the governors and President of India. So initially there was a judgment by a bench of Justice Pardiwala, which said that reference under Article 143(1) was sought by the President.
I'm sorry to disturb you, sir, but may I just request you to kindly check your internet connection? It is getting stuck in the mid session, sir. It has happened quite some time. If you can
Okay,
just, yes.
just a minute. Am I audible, but or not at all?
No, sir. It is in the parts. Your video also stops, and you're also not audible.
Okay, just a minute. I'll change my internet connection then.
Sure, sir.
Yes. In fact, now it is showing unstable.
Yeah.
The first,
So for the major part, you are clearly visible and audible, but for quite 15-20 seconds, it is the audio and video both are getting lost.
now how it is? Because I'm trying both the internet connections and I don't know. Is it okay now?
Sir, we'll have to see in the course of time.
Okay.
Yeah.
You may just tell me. I'll
Yes,
continue
yes. So,
now.
so right now also, when you mentioned Justice Pardiwala judgment, thereafter
Uh,
nothing was audible.
Acha, okay.
Yes, sir.
So am I audible now? So should I continue?
Yes, sir, you're audible now. Please continue.
So there was a judgment by Justice Pardiwala which ordered that there should be the governors and the president of India is amenable to the writ jurisdiction, and the courts can direct the governors and the president to give assent to the bills that are passed by the legislature. So that was done under Article 142 of the Constitution, which I'll discuss in due course of time. But this direction was given by Justice Pardiwala. Therefore, so this was a very landmark judgment, but then government as in president sought reference under Article 143(1) of the Constitution of India and put a question to the Supreme Court that whether there can be any timelines on assent of the bill, or the second question was whether governors and president can be directed by the Supreme Court or the high courts to grant assent to the bill. And this reference was answered by Constitution bench. Just I wanted to give this example, so I told about Article 143. Second is reference by president.
Sir, I'm again sorry to disturb you, but this time neither the screen is visible nor your video is visible.
Okay, I'll not uh, turn turn on my video, so maybe some bandwidth will be saved. What do you think?
Sir, we can try that, but the screen is still not visible, sir.
No, I have stopped sharing the screen.
Okay,
Can
so
you
so
hear?
now you were visible for a moment, sir.
No, so I'll just turn off my video because then some bandwidth will be saved. Okay.
Okay, sir, sure.
And again, you may interrupt me because now
Sure,
I
sir,
have
sure.
stopped. I am sharing my
Yes,
screen. Okay.
yes, it is visible, sir.
Now you can see the note.
Yes, sir, yes, we can see the notes.
Yeah. Okay. I don't know what the problem is because this is my Wi-Fi connection. It's not mobile connection. Okay, so should I continue now?
Yes, sir, please.
Yes. So the second reference is under Article 143.2, read with Order 42 of the Supreme Court rules, of a dispute of the kind mentioned in the proviso to Article 131 of the Constitution. Now, as we saw that in Article 131, so under this proviso to Article 131 of the Constitution, President can seek reference of the Supreme Court's opinion that if there is interpretation of any treaty or any agreement between two states or two or more states that existed before Constitution was adopted. So such reference can be sought by President under Article 143.2. The next is reference by the President under Article 317 of the Constitution, read with Order 43 of the rules, in relation to an inquiry for removal of the chairman or any member of a public service commission from his office on the ground of misbehavior. So this is self-explanatory. Next is reference by President under Section 14 of Right to Information Act, read with Order 43 of the rules. Fifth is the reference by the Governor under Section 17(1) of the Right to Information Act or any other statute under Order 43 of the rules. Next is reference under Section 257 of the Income Tax Act 1961, read with Order 45 of the rules by the Income Tax Appellate Tribunal. And last one is reference under Section 11 of the Competition Act. So see, if you see, there are references which derive some powers from Constitution and others are references under the statute. The next is inherent and plenary jurisdiction. So what is this inherent and plenary jurisdiction? Supreme Court, as you know, you have read it many times, either High Court or Supreme Court. They are the courts of record. So Supreme Court is one court of record. What does it mean? That if any order is passed by the Supreme Court, that obviously one meaning is that is under in the records of the Supreme Court. But the meaning of it is, if that order is not adhered to, a contempt petition can lie in that specific court. That is, one is High Court and other is Supreme Court. Therefore, there are two types of contempt. First is contempt petition civil. How it is filed, that this is important. So in Supreme Court rules, there is no mention of contempt petition, but it is governed by Contempt of Court Act, and there are rules to regulate proceedings for contempt of the Supreme Court. Those rules were formulated in 1975. So the petition under Rule 3 of these rules, read with Section 2B of the Contempts of Court Act, read with and Articles 129 and 142 of the Constitution, shall be registered as a contempt civil. Then there is contempt petition criminal. A petition under Rule 3 of the rules to regulate proceedings for contempt of the Supreme Court 75, read with Section 2C of the Contempts of the Court Act 1971. Now there is a subtle difference between civil and criminal contempt. If an order is violated, that a Supreme Court passes certain order and that is violated by the party, then directly a contempt petition civil can be filed. But what is this contempt petition criminal? It is not violation of any order passed under criminal matter. But if, for example, you see many instances now on social media that there are comments by various persons on the courts, especially Supreme Court, and while making those comments, many a times parliamentary language is not used. Some words are used which are abusive. So in such cases, when a contempt petition is filed, it is filed under this jurisdiction, that is contempt petition criminal. And how it is done, I have not mentioned in this note, it is not there, but you have to write to Attorney General of India or Attorney General for India, and he will take a decision that whatever, for example, actions that are taken by the alleged contemptor amount to contempt, and therefore a contempt petition will lie before the Supreme Court. And this will be criminal contempt petition. Next is the review petition. Obviously, every court has power of review, especially High Court has power of review. Some tribunals have powers of review. In similar manner, Supreme Court also has powers of reviewing their own order. An application for review under Order 47 of the Supreme Court rules, read with Article 137 of the Constitution, and shall, as far as practicable, be circulated to the same bench of judges that delivered the judgment or order sought to be reviewed. Yes, it is natural if a certain judge has passed any order. The judges go through the file. If judges find that there is uh, some point in the review petition, then they will issue notice and list the matter for in uh, in the court for open hearing or for oral hearing. Till then, the review petitions are only before the chamber. So this point you may note it, because again, as I said, this is a very different procedure in Supreme Court. We think that after the main petition is dismissed or we have to seek order, we will immediately get opportunity to argue. That is not the case. Next is curative petition. So this curative petition is innovation by the Supreme Court itself. After review petition is dismissed, what lies is the curative petition. So this curative petition is under Order 48 of the Supreme Court rules, which will be circulated to and heard by a bench of the three senior-most judges and the judges who pass the judgment or order complained of, if available. Unless otherwise ordered by the court, a curative petition shall be disposed of by circulation without any oral arguments. If the bench before which the petition was circulated concludes by a majority that the matter needs hearing, then it shall be listed before the same bench as far as possible. Now, what is this curative petition? You may make a note of one judgment, that is Rupa Hurra versus Ashok Hurra. From this judgment, the curative petition or the curative jurisdiction of the Supreme Court was conceptualized. So after review petition is dismissed, there should be some option with the litigant, and if litigant is able to show that there is ex facie injustice and principles of natural justice were not followed while passing the orders in review petition or prior to that, maybe in main special leave petition or by the High Court or by the lower courts, then a curative petition can be filed before the Supreme Court. This is under Order 48 of the Supreme Court rules. Now, what are the requisites of curative petition? I have not mentioned it here, but a curative petition has to be necessarily accompanied by a certificate, and that certificate should be given by a designated senior advocate. So that senior advocate can be anyone who practices before the Supreme Court or who is designated by the High Court. But that senior advocate should specify in the certificate that the questions of law raised, or there has been injustice, ex facie injustice, or there has been no adherence to the principles of natural justice while passing the orders, and therefore this curative petition be accepted by the Supreme Court. This kind of certificate has to be given by the senior advocate. And only after this curative petition is accompanied, as I have mentioned it in the note, it will be listed before the senior most judges and also judges who were part of the bench. One or two judges, if both the judges are available, then 3+2. So it will be 5-judge bench who will again not listen the matter. They will decide in the chambers that whether this matter needs consideration. If I must tell you, since I believe that most of us from Maharashtra, but this case is known to everyone, a very famous curative petition is pending before the Supreme Court, and that pertains to Maratha reservation case. I don't know what is the progress, but that curative petition is pending, and you might be seeing that whenever that curative petition is listed, there is always a news in media that this curative petition is listed before the court today. But I think so as of now, the permission for open hearing or oral hearing has not been granted. But then you will also verify. I'll also verify this. It came to my mind suddenly while discussing this. Then the next part of the plenary jurisdiction is Article 142 of the Constitution of India. This is a special provision available only with the Supreme Court. In appropriate cases, to do complete justice, the Supreme Court is empowered to pass such orders as may be required to subserve the cause or meet ends of justice. Article 142 is a unique provision. It grants Supreme Court power to pass any order necessary to secure complete justice. I think so. This is self-explanatory, but I would like to talk more about this. What does Supreme Article 142 say? I'll just read the text for you. As we can understand, in many cases, so there is Supreme Court feels that a complete justice can be made. The best example that I would like to quote here is the dissolution of marriage. What generally happens in practice? Husband files a divorce petition, let's say in Madhya Pradesh. Wife is residing in Maharashtra. She files a transfer petition. We have seen Section 25 of Code of Civil Procedure. She files a transfer petition before the Supreme Court of India for seeking transfer of divorce proceedings from Madhya Pradesh to Maharashtra. Notices are issued. Husband enters appearance. The matter is referred to the mediation. If at all the parties settle their disputes, settle as in settlement is both ways. Either they decide to live together or they conclude that no, we can't stay hereafter. So a settlement deed is entered into, compromise terms are entered into, and it is decided that we are going to separate, we are going to part our ways. In such cases, Supreme Court exercises its powers under Article 142 and dissolves the marriage. So this is on the grounds of irretrievable breakdown of marriage and also because there is settlement. So this is one example of Article 142 which I thought I should tell you and everyone knows about it. But then there are many other cases where Supreme Court exercises this power to do complete justice. Sometimes it is for sentences. Maybe it is not correct way to do it, but many a times there are few judgments where sentence has been reduced. So, for example, a convict who is 85 years old and he's been granted 6 months of sentence, but it is a mandatory minimum sentence. Still, Supreme Court has exercised Article 142 and uh, let off the convict in whatever for whatever period he has undergone his sentence. So this is again just one example. So this power, Article 142, is obviously has to be used in sparing manner, but still Supreme Court tries to use it in many other ways and in many other cases. Okay, then what are the benches? So like in High Court also, there are single judge bench, there are division benches. In similar manner, in Supreme Court, there are single judge, two judge, three judge, five judge benches. So this part is very important because single judge bench derives their powers from Order 5 Rule 2 of the Supreme Court rules. Okay, so if you read Order 5 of the Supreme Court rules, you will come to know what are the powers of single judges. For example, there are powers where supreme single judges can issue notice in transfer petitions, or they can deal with the transfer cases directly. There are cases where bail can be granted by the single judge, where sentence is maximum 7 years. In such cases, bails can be granted, but I have not seen that these matters are listed, especially the bail matters before the single judge benches. Then in exercise of powers conferred by Order 2, Rule 6 of the rules, the Chief Justice may direct matters of urgent nature to be heard by a judge sitting singly during summer vacation or winter holidays. Now, the summer vacations are just starting in Supreme Court from 30th May. 29th May is the last working day. So, if need be, in summer vacation, actually, vacation partial court working days, they have started calling it now. Two judges only preside, so that is division bench only presides. But if need be, Chief Justice may also direct that matters of urgent nature can be heard by judge sitting singly. The third point is the Supreme Court rules 2013 are partially amended by rules of 2024. Order 2 of the Supreme Court rules is substituted, and instead of vacation judge, the words partial court working days is substituted, as I told you earlier. Further, under Order 38 of Rule 1 is substituted after amendment. Petition under Article 32 shall be heard by court of not less than 5 judges, provided that petition which does not raise substantial question of law as to the interpretation of Constitution will be heard by court of less than 5 judges and during partial court working days. Now, this is actually in consonance with Article 143.5. Sorry, 145.3. What it says, the minimum number of judges who are to sit for the purpose of deciding any case involving a substantial question of law as to the interpretation of this Constitution, or for the cause appeal or other proceedings arising out of a case in which death sentence has been confirmed or awarded by the High Court shall be heard by a bench consisting of not less than 3 judges. So, if there is a death sentence that is awarded by the first Sessions Court, then confirmed by High Court, that matters will be necessarily heard by a bench of 3 judges. Third is in exercise of powers conferred by Order 2, Rule 6. The Chief Justice may direct matters of urgent nature to be heard by a division court during the vacation. So this is what I have told, that in court vacation, division benches preside, and they can be listed before the single judge as well if the Chief Justice directs so. Third is the Constitution bench. So every case involving a substantial question of law under Article 145.3. This is what I read just now some time ago, the provision Article 145.3, or any reference made under Article 143 of the Constitution shall be heard by a bench consisting of not less than 5 judges. So as we saw that presidential reference, all the presidential references are to be heard by a bench of minimum 5 judges. Next is every petition calling in question the election of the president and vice president under Article 71. Again, these petitions also will be heard by a bench of 5 judges, that is Constitution bench. Then Chief Justice may from time to time constitute a bench consisting of 5 or more judges for the purpose of hearing any other case, appeal or matter. The next is reference to larger bench. Now, how this is done? There is a judgment, let's say, by a judge of 2 judges. They take certain view in the matter. Then there is another judgment by another 2 judges, which take completely opposite view in the matter. Now there is a third matter where these 2 judgments are cited before that bench. Now they notice the difference in opinion of first bench and the second bench. In such cases, this matter will be referred to a bench of a larger strength. So if this is a division bench, then that will go before 3-judge bench. For example, there is a difference if there is a difference of opinion in 2 judgments and it involves the interpretation of the Constitution, then that will be referred to the Constitution bench under Article 145.3. So this you may keep it in mind that how the references are made. Even in High Court, there is a reference to full judge bench. So this is again a common practice. This is similar to High Court. I'm not reading this because you may just go through it how it is done. Okay. Now I am coming to the next part. The screen is visible, right?
Yes, sir, it is visible.
Yeah, okay. Then this is the practice part. I'll deal with it. Filing to listing. How is the matter filed and how it is listed? So obviously, first is I'll just give an illustration of any High Court order. Let's say a bail matter. Bail matter is there is a order passed by High Court rejecting the bail. Now that client comes to you. First, you obviously get instructions from the client. So what are those instructions actually? So first is you send your wakalatnama, you send the affidavit. In bail matters, so there is a requirement that wakalatnama should be stamped from the jailer. So that requirements are fulfilled. You draft the special leave petitions, you prepare the SLP, and you get it filed through your clerks. So this can be e-filing or physical filing. So as I told you in the start that currently the e-filing is governed primarily by e-filing user manual 2.0, and there is 3.0 also, but it is not yet fully functional. So you do the filing through that portal. Then second is, what is the role of advocate on record? So this is the role of advocate on record. What I said, that till you prepare the SLP, your role ends, then the role of clerk starts. What happens after the SLP is filed? The registry checks the special leave petition. Then they see that what are the defects. There are different type of defects notified, that pages are illegible. There are some pages which are in vernacular, or So it can be exemption from filing certified copy of order. It can be
Sir,
exemption.
sorry to disturb you again.
Ah,
The last thing that we heard was the pages are vernacular. From then, nothing was audible.
okay. Sorry. Yeah. So is it okay now?
Yes, sir. The issue is not with you. There is something with the Zoom. I'm also seeing some participant leaving the moment your audio is not audible.
Acha. Okay.
Yes, yes,
Okay, no problem.
yes.
You just interrupt me, I don't mind. I'll just understand.
Sure,
Yes,
sir.
so these type of defects are notified. That those defects are cured by either advocate on record or clerk of advocate on record, and accordingly, the matter is ready for listing. What are the types of applications? I was on that actually. So there are different types of applications which are filed with the special leave petition. So one is exemption from filing certified copy of order. Now this is a very interesting application because what happens is high courts or now in any other court, the orders are down. Like we get the orders in e-file, e-mode or electronic mode. Those orders we annex it to SLP. Along with it, we file the certified copy of the order. Then I'll come to this certified copy. Why I have to tell one interesting aspect, what is happening nowadays. Then there are applications like exemptions from filing official translations. So why this is to be filed? Because there are, for example, FIR is in Marathi. We get it translated from either uh, either we translate it, get it translated from local translators who actually know both the languages, Marathi and English. So they translate it from Marathi and English. We annex that FIR along with the original copy. And since he is not official translation, translator, we file the application for seeking exemption from filing official translations. So this is for where we don't get documents translated officially, because that process is very tedious, which will take at least 7 days for translation of one FIR. So this is generally done. Then there are other applications if there is delay in the matter. So special leave petition has to be filed generally after 90 days after the order is passed. But if it is not preferred within 90 days, then application for condonation of uh, delay in filing special leave petition, that application is required. Now I'll tell you an interesting story about the certified copy of the order. What we do is we, in our applications, we take a plea that the certified copy of the order is not available, and therefore we are filing the electronic copy, and as and when the certified copy will be available, we will produce it before the court. Now, these type of applications are being actually reprimanded by the Supreme Court, and that too by the honorable judges. They want, they feel that if you are preferring if you are preferring the SLP, you can come up with the certified copies. And the explanation that we provide is that we do not have certified copies. So there is a requirement now to make a statement that whether you have applied for the certified copy or not. So if that statement is not there, even on that counts, the special leave petitions are being dismissed. So whether this is right or wrong, I don't know, but what is happening in practice? So again, there will be a suggestion. I am been giving this suggestion to you 2-3 times, that what you have to do as a lawyer. That if there is any matter you refer to the Supreme Court of India, try to get the certified copy. And for statutory appeals, they have actually made the certified copy compulsory. Now the appeals won't be processed by the registry if there is no certified copy. And in fact, there will be each day, so you will lose each day if you don't provide the certified copy. Therefore, in statutory appeals, for example, from NGT or NCLAT, an appeal is being preferred, the Supreme Court has issued practice direction that this appeal will be filed only with the certified copy and not electronic copy. Then comes the next part, is mentioning. So before mentioning, I'll tell you one thing. When we talk about criminal matters, especially bail matters, and matters where there is a caveat by other side. You have to make service on this in bail matters on the Standing Council for States. If your matter is against State of Maharashtra, then Standing Council for State of Maharashtra, and in civil matters or in any criminal matters, if there is a caveat, if we don't serve it on caveat. So this is a safeguard that has been adequately given for the uh, party who files a caveat. Then comes the mentioning. So what is mentioning? So in Supreme Court, till Justice Gawai was the Chief Justice, there was a process of mentioning. You file a matter, immediately you write to the registrar, that is mentioning registrar, that this is the urgency in my matter. If the matter is not listed, then my rights and contentions are seriously my rights are seriously affected. So this matter may be listed on the urgent basis. So this process was there till Justice Gawai was Chief Justice of India. After that, Justice Suryakant has become Chief Justice of India. He has made procedure little bit different. What he has done is that after filing the matter, you should cure all the defects, get the special leave petition number, and then you can mention it. And along with it, he has also permitted oral mentioning before himself. Like in court one, you can mention the matters, or you can give the mentioning slips, which will be considered and matters will be listed. So this is process of mentioning in Supreme Court. Then how is the matter listed? I actually forgot to put that link, but you can just go to Supreme Court website and see that there are roster of judges. So this Chief Justice time to time issues rosters, and every judge is assigned certain rosters. Now it is again not like High Court where we know that we have certainty that bail matters filed in 2026 or anticipatory bail matters filed in 2026 today, for example, if court is functioning, it will be listed before XYZ judge. In Supreme Court, that is not the case. In Supreme Court, what happens? All types of matters are listed before all judges, except few. For example, some tax matters are listed before 2 or 3 judges. We know that our matter will be listed before some judge out of these 2, 3 judges, but we don't have any certainty. So this is as per the rooster, or there can be any other direction by the Honorable Chief Justice of India because he is master of the rooster. What is the process after listing? Let's say that it is a special leave petition. I would like to tell you one thing on a lighter note, that if you are filing a special leave petition or any other proceeding in Supreme Court, 90% of the matters will get dismissed. So there are only 10% or 15% matters in which notice is issued. So that is because Supreme Court is the or Article 136 is the extraordinary appellate jurisdiction, and it is not like civil appellate or criminal appellate jurisdiction. Therefore, notices are issued in very limited number of cases. Now, what happens after listing? After listing, after notices issue, if it gets dismissed, then it's game over. But then, if notice is issued, you have to file a process fee in the registry. Now, what is this process fee? If there are 5 respondents, then you have to either pay the fee of 5 copies or directly submit 5 copies in the registry, which in turn will issue notices to the respondents. Those will be served. Then thereafter, the respondents will enter appearance. Then they will oppose the special leave petition. And if court is convinced that there is no point in the special leave petition, it will get dismissed. Or if court is convinced there is point in it, then there are two things that can happen. That first is they'll hear the matter before granting leave, because as we know, in special leave is the special leave to appeal. So if that special leave to appeal is granted, then it is called as leave granted. So either Supreme Court will grant the leave and decide the matter immediately, or it will grant the leave and admit the matter for further hearing. So generally, leave granted matters are like admitted matters in the High Court. So those matters will come up after, let's say, 7-8 years. Criminal matters will come little early, but civil matters will take even 10-12 years of time. So this happens after listing and notices, if notices are issued in the matter. That's with the procedure. Now this topic, as I said in the start, this is not related to procedures, but I would like you to just go through this debate at all, every, like, you should know, that is what I feel. So what is the basic?
Sir, the moment you started with the appointment part, the audio was gone.
So sorry, yeah, I don't know
Yes, no,
what is the problem.
yes, sir. So this is not with your Wi-Fi actually, I feel.
Am I audible now?
Yes, sir, you're audible.
Okay. So I will just repeat what I was saying. So this needs to be studied in some perspective, because appointment of judges is always there in the news. So maybe it is collegium system, functioning of collegium system, transparency in appointments of the judges, whether there should be executive interference or not. Generally, the examples of other jurisdictions are cited, like US and UK, where executives appoint judges, and it is always said that India is the only country where only judges appoint judges. So this needs to be studied in some perspective. And obviously, again, the first is the Article 124. It What it says, Article 124. Establishment and Constitution of Supreme Court. First part I will not read. Second is, every judge of the Supreme Court shall be appointed by the President by warrant under his hand and seal, and shall hold office until he attains the age of 65 years. Okay. Sorry, I am actually having the NJAC version of the Bear Act. But then I'll just tell you the procedure, that under Article 124(2), the appointment of Supreme Court judges is provided. So generally, how is the Supreme Court judge, how used to he be appointed before the birth of collegium system? So there used to be consultation. consultation with whom? President used to appoint Judge of Supreme Court of India in consultation with Chief Justice of India. So that process used to be very streamlined. Judges or the prospective judges of Supreme Court were used to be, the names used to be considered first by the president, that is the government, and the Chief Justice of India, and both of them would reach to some conclusion, certain conclusion, and Supreme Court judges were appointed. The first problem started obviously in the emergency, where you know that there were two times there was supersession where Chief Justice of India was not appointed, especially Justice H.R. Khanna for his judgment in ADM Jabalpur versus Sivkant Shukla. He was superseded and he was not appointed as Chief Justice of India. Therefore, a tussle between executive and judiciary started with respect to the appointments. And there was the first case in 1980 that was called as S.P. Gupta versus Union of India. So S.P. Gupta was actually a practicing advocate, and he filed this first writ petition. If you would be it would be interesting to know that S.P. Gupta case is not only did not only give the birth to this debate of appointment of judges, but it is also considered as a first case for the birth of public interest litigation in India, where locus standi or the rule of locus standi was relaxed, because S.P. Gupta was neither a affected party because he was just an advocate, and it was not the case where his appointment to judgeship was rejected, but he filed this that how much executive interference should be there. So in 1980 this judgment was delivered appointed. So so the primacy of the appointment of the Supreme Court judges lied with the government from 1980 till 1993. So this 1980 case is generally called as first judges case. In 1993, there was a second judges case. So this was filed by actually Supreme Court's Advocate on Record Association, so I am an advocate on record, and this is the case which was filed by the Supreme Court Advocates on Record Association for streamlining the process of appointments where there was excessive executive interference and there was no primacy given to the Chief Justice. There was no proper consultation also while appointing the judges of the Supreme Court and also the High Courts. So in that, there was a birth of a system where it was held that consultation means concurrence. So whatever Chief Justice will say, that will be the... So Chief Justice was given primacy for the appointment of judges of the Supreme Court and the High Court in the second judge's case. But then there was a problem that why only Chief Justice? There should be few more judges to assist him. So it can't be the individual decision, but there should be a group of judges who will appoint the judges. So this was the birth of collegium system in 1993. That is, in 1993, the collegium consisted of Chief Justice and two senior most judges. Thereafter, in 1998, there was a presidential reference. Now you know that what is presidential reference we have seen under Article 143. So it pertained to the appointment of judges in the Supreme Court and the High Court. So in this third judge's case, it was held that collegium will consist of Chief Justice of India and 4 other senior most judges. So this was for the appointment of the Supreme Court judge. And for the appointment of High Court judges, it is Chief Justice of India and the 2 senior most judges. So this is how the collegium system was born in 1993, finalized or as it is today in 1998. And even today, we have the collegium system, which is as per the third judge's case. In between, there was NJC, National Judicial Appointments Commission. You will obviously read about it more if you just read the judgment of 4 judges' cases. Again, that was filed by Supreme Court of Advocate on Record Association. So there was a constitutional amendment to change the appointment system of the Supreme Court and High Court judges, but that was not liked by the Supreme Court, saying that judicial independence is being hampered, and that was I feel it was rightly so, because the Chief Justice was not getting primacy, obviously, but then there were 2 other members from the civil society who would be appointed by government, and then they would be appointing the judges. So there was again tussle between the executive and judiciary, and therefore this 2015 NJC Act was struck down by the Supreme Court in 4 judges' cases. And that is why, as I said, we have collegium system today, which is Chief Justice of India and 4 senior most judges for Supreme Court and 2 senior most judges for High Court. This is how it is functioning. There are other developments also, like there is a memorandum of procedure which is yet to be finalized as per the NJAC judgment, which is not yet finalized, that there should be say for executive also. But then these are the issues that you can debate and you can read, study. I just wanted to give some glimpse of this. So therefore, this is not related to practice and procedure, as I said. That's it. This is my lecture from my side.
Dear participants, if you have any questions, kindly raise hand. Sir, it appears there are no questions as such. Am I audible to you, sir?
Hello, sir. Hello.
Yes.
सर 142 नुसार आपली जी केस आहे आता शिवसेनेची, तर सुप्रीम कोर्ट आर्टिकल 142 नुसार येते सर ऐकायला?
हा
हॅलो.
येते.
तर आर्टिकल 42 नुसार सुप्रीम कोर्ट ही शिवसेनेची केस म्हणा किंवा मराठा आंदोलन केस स्वतः घेऊ शकत नाही का निर्णय? त्यात दिलंय ना 142 नुसार सुप्रीम कोर्ट अलाव करू शकतो, म्हणजे स्वतः घेऊ शकतो ते निर्णय तात्काळ.
नाही, ऍक्च्युली का नाही करू शकत मी सांगतो तुम्हाला.
हा.
फर्स्ट ऑफ ऑल इंग्लिश मध्येच सांगू का, कारण की मग हे बाकीच्यांनाही कळेल.
ठीक आहे, इंग्लिश नाही सांगा, काय हरकत नाही.
हा,
मला दोन्ही येतं बोलत, तुम्ही आपण मुंबईचे तर म्हणून मी मराठीत
नाही,
बोललो.
बाकीचे पण आहेत ना, म्हणून मी फक्त एकदा
नाही,
इंग्लिश.
ठीक आहे, काय हरकत नाही, इंग्लिश नो प्रॉब्लेम.
So basically his question is that the dispute that is pending between the factions of Shiv Sena. So these are the political parties from. This is a political party from Maharashtra, and you know everything, but still, so this dispute is pending before the Supreme Court, and he is asking that can't Supreme Court invoke Article 142 to do the complete justice between the parties? Now there is a reason why this can't be done. First of all, if you see, it is the symbol order that is being challenged in the Supreme Court. Only symbol was allotted by the Election Commission of India to one faction, symbol of bow and arrow, Dhanushyaman. That was allotted to one faction, and that is being termed as real Shiv Sena now. But that is only the symbol order which is challenged in the Supreme Court, is what I know as of that. Again, that is the interim order. But this can't be done because in whose favor, what complete justice you are going to do in this? This has to be heard finally. Complete justice is done in such cases where there is purely a factual determination in the matter. For example, if I had told you about the matrimonial dispute, there is a factual determination that both the parties don't have to reside together. They arrive at the consent terms or settlement deed. Therefore, Supreme Court factually determines, or there is a factual determination before the Supreme Court, that there is irretrievable breakdown of marriage, and therefore the marriage needs to be dissolved under Article 142 of the Constitution of India. Now, just see it in the Shiv Sena case. How it can be done, in whose favor it can be done, or these questions, or what complete justice. So if Supreme Court says that we have to do complete justice, and they feel that the order that was passed by the Election Commission of India is correct, will it be a complete justice? Or you otherwise, Supreme Court feels that Election Commission of India's order is not correct, and therefore by Article 142. So these issues cannot be, Article 142 cannot be exercised in such cases, according to me. That just going legally. Obviously, then there are sentiments, political sentiments, there are political workers who may have allegiance to one faction and other faction, whatever it is. But where is the factual determination of that? That's why it cannot be done.
Okay, thank you, sir.
Yes.
Thank you. Sir, federal court's decisions are allowed by the Supreme Court on what basis? Federal
Sorry.
court decisions. Federal court's decisions are allowed by Supreme Court, no?
Federal court, as in which court you're talking about?
Federal court means other countries.
नाही समजत आहे. हॅलो.
म्हणजे भारताच्या बाहेरच्या कंट्रीजचे जे आहेत ना फेडरल कोर्ट.
अच्छा, ओके ओके. So
बोला.
you're talking about US UK courts, correct?
Yes. That decisions are allowed by the Supreme Court.
So actually those can be cited, but then they have the persuasive value just to get some guiding principles. Now, for example, generally we follow common law system, and which is based on the legal system of the United Kingdom.
But lateral, according to our Constitution 135 Article 135 says that federal court decisions are allowed by the Supreme Court of India. Sir, understand? Hello? Hello, not audible. Hello, sir. Sir, not audible.
Hello.
Not audible, sir.
No, I was muted actually. Yeah.
Okay.
So
According to 134,
hmm,
sorry, 135,
okay.
federal court's decisions or any litigation decisions are allowed by the Supreme Court.
135 of the Constitution.
Yes, 135.
Okay. No, sir. So what is this? Before Supreme Court of India was
Yes.
to existence, there was a federal court in India. So actually, so
Federal court in India means which court? Federal court.
So that was the Supreme Court. That was the highest court in India. And federal court's decision used to be appealed in the Privy Council, if you have seen. If you have heard about the Privy Council many times.
Yes,
So,
yes.
so maybe I'll confirm that. I'm not sure, but federal court was the previous to Supreme Court of India. So Supreme Court of India came into existence in 1950, right?
Before existence of the federal court or Supreme Court means
Yes.
Constitution. Before the Constitution of India.
Exactly. Before Constitution of India, there was a federal court. And actually, it was there in the Parliament House. So the first Supreme Court came in 1950, and it had only 5 judges. That is Chief Justice of India and 4 other judges. So if any one of you have traveled to Supreme Court, you will see that there are 5 courts in the front. That was the Supreme Court, and rest was the registry. But now there are 17 courts actually, and 2-3 courts are even they are very small. So that was what you are referring to in Article 135. That is federal court prior to Constitution of India.
Okay. Thank you, sir.
No problem.
Sir, it appears there are no further questions, and also we are out of time for today's session.
Oh,
So,
so
with
sorry.
your permission,
Yeah.
no, sir, no, sir. It is something that was beyond our control. So, shall I conclude the session then?
Yes, definitely.
Yes, sir. So, sir, I sincerely thank you for today's insightful session. The way you explained the subject with such clarity and practical perspective has given us a deeper understanding and much more to reflect upon. Legal Expatiate is really grateful for your time and efforts. Thank you once again, sir.